Hello everyone, this is LawSahyogi and today we will be discussing section 101 of the Bharatiya Nyaya Sanhita 2023. So, this section deals with murder. Now, to put murder in simple terms, we can define murder as killing of an individual or human being. Murder can be defined as a type of culpable homicide that involves the intention to kill a person through a deliberate and a premeditated act. Now, to go further into the explanation of murder, we see there exist three key points. That is, to constitute murder, there has to be a strong intention to cause death, and secondly, there has to be knowledge. That is, the perpetrator has to have the knowledge of the fact that the action that he is going to take is so imminently dangerous that it is likely to cause death or cause such level of bodily injury that is sufficient to cause death. And thirdly, there has to be the presence of special circumstances. The act must fall within aggravated scenario. That is, the act has to contain extreme brutality, the act has to contain a premeditation, or the act has to contain situations like attacking defenseless individuals. Now, to understand the concept of murder, we first need to understand the difference between culpable homicide and murder, though the difference is subtle, but yet it is very important. Now, culpable homicide also refers to killing of an individual or human being and can be defined as killing of an individual or human being, but the difference lies in the aggravating factors. Here, we can term culpable homicide as the umbrella and murder comes under that umbrella. Here, to constitute culpable homicide, intention is necessary, knowledge has to be there, okay, but in murder these intent and knowledge has to be in an aggravated format or an aggravated form. The brutality has to be higher, the intensity has to be higher, and there has to be a premeditation which is completely absent in cases of culpable homicide. So we can say that murder is an aggravated form of culpable homicide. So now we come to the point where culpable homicide can be considered as murder. So there are three situations. If the act by which death is caused, these three ingredients, then culpable homicide will be considered as murder. So the first is that the presence of intention. So there has to be a strong deliberate intention of causing death. Secondly, the intention, there has to be an intention of causing such level of bodily injury which is most likely to cause or result in death. And third, the person committing the offense, the offender, has to have the knowledge of the fact that the action he is going to perform is so dangerous that in all probability the result of the action will ultimately be death of the person upon whom the injury is inflicted. Now we come to the illustration part that will clarify when culpable homicide can be considered as murder. Now suppose A shoots Z with the direct intention of killing him, and Z dies in consequence. In this case, A has committed the offense of murder. Secondly, we see that A intentionally injures Z with a sword. He gives him a cut, and and as a consequence Z dies. Okay, but in normal a course of nature, if we see, that injury was sufficient to cause the death of any person upon whom it is inflicted. Here A is guilty of murder, but we see that there is a absence of intention, but still A will be considered has committed the offense of murder, because the gravity of the injury is such that in common parlance it is evident that whosoever receives that kind of injury is likely to be the victim of death. And thirdly, the third illustration states that suppose A, without any excuse, fires a loaded cannon onto the open public, and as a result of that one of them dies. Here A is guilty of murder, although there is no pre-planned design to kill any particular individual, but the gravity, the extremity of the act is such that if you load a cannon and randomly shoot crowd, it is destined that someone will get such bodily injury or death itself from that injury. Now we come to the point where we will be discussing when culpable homicide will not amount to murder. So the section 101 has 5 exceptions, and these exceptions lays down the situations when culpable homicide will not be amounting to murder. So the first exception states that in cases of sudden provocation, sudden or grave provocations, if a person loses his self control, and after losing due to that provocation he causes the death of the person provocating or any other person, in those cases the culpable homicide will not be amounting to murder. But here two things has to be taken into consideration, is that the offender shall not sought or voluntarily be provoked as an excuse to do the harm, nor the provocation is caused by anything done in obedience to law or exercised by a public servant in the exercise of his lawful duties. And the third is that in the cases of private defense, okay, for example, in order to exercise a person's right of private defense, he is suddenly provoked, he is suddenly or gravely provoked, and due to that provocation he causes the death of the person provoking or any other person. In those cases the culpable homicide will not amount to murder. Now we come to the illustration part of exception number 1. Here we see that suppose A, under the influence of passion excited by a provocation given by Z, intentionally kills Y, who is his child. So this will amount to murder, because the provocation was not given by the child and the death of the child was not caused by an accident or misfortune, as the killing was intentional. And secondly, we see the illustration that suppose Y provokes by sudden provocation, and due to that provocation A takes out a pistol and fires at Y, neither intending nor knowing himself likely to kill Z, who was near him but out of sight. Here the fact is that A has killed Z, but here A has not committed murder but merely culpable homicide. Now we come to the exception number 2. It states that while exercising the right of private defense in good faith, if someone exceeds the power given to him by law, causes the death of a person against whom such right of private defense has been exercised, and in this case there has to be the absence of a premeditation or any pre-intention, then the culpable homicide will not amount to murder. So now we come to the illustration of the exception number 2. For example, Z here attempts to horsewhip A, not in such a manner as to cause grievous hurt, and as a result A draws out a pistol. Z persists in the assault. A believing in good faith, he cannot by no other means prevent himself from being horsewhipped, shoots, and he dies as a consequence. So A has not committed murder but only culpable homicide. So now we come to exception number 3. Here it states that when a public servant or a person aiding such public servants who is working towards the advancement of public justice exceeds his power and causes the death of a person which he believes in good faith necessary for the lawful discharge of his powers, in this case the offence of culpable homicide will not amount to murder. And now we come to exception number 4. Here it states that an act without a pre-planned design or premeditation shall not be considered as murder, just culpable homicide. The act will not amount to murder if the offender does the act without any pre-intention, example being during sudden fight or altercation emanating from heat of passion. Now exception number 5. Exception number 5, we see that the act will not amount to murder if the person whose death is caused by his own efforts or he takes the risk of it on his own volition. Under exception 5, suppose a person causes the death of a person and the deceased has taken the risk out of his own volition, in that case the offence will not constitute as murder but as culpable homicide. Now let us see certain case laws that will give us a clarity on the definition and concept of murder. We will be discussing the state of Andhra Pradesh versus R. Punaya. Now in this landmark judgment, we see a difference being drawn between the offence of murder and culpable homicide not amounting to murder. Now section 299 was culpable homicide not amounting to murder, and section 300 defines murder under the then Indian Penal Code, which is now replaced by the Bharatiya Nyaya Sanhita. The court explained that all murders are culpable homicide. All murders are culpable homicide, but not all culpable homicides amount to murder. The distinction lies in the degree of intention or knowledge and the surrounding circumstances, the thing which we have discussed earlier also. Now, the nature of intent and injury. Now let's discuss the gravity of nature and injury. If the act is done with the intention of causing death or such level of bodily injury that is likely to result in death, it could fall under section 300, that is murder, and if we refer to BNS, it will be section 101. However, if the act lacks the premeditation or sufficient knowledge of the consequence, it may fall under section 299 of the IPC and now section 101 exception. So now we come to the part of gravity of the act. Now what will determine the gravity of the act? The court highlighted that murder involves a greater degree of mental culpability as compared to culpable homicide. So the court has highlighted that murder involves a greater degree of mental culpability, including a pre-planned design and extreme recklessness. The judgment sets parameters for identifying knowledge versus intention in criminal acts. Now we will talk about the application of legal principles. The case has become a landmark in defining the subtle but significant differences between the two offences. Now, we have earlier also discussed the difference between culpable homicide and murder. The difference between culpable homicide not amounting to murder and murder. Okay, to be in the clear picture, we have differentiated between culpable homicide and murder. The differences are so subtle, very little, but yet the differences help us to know the gravity of the two offences. Now we will talk about another case law, and now we will talk about the legal principles established. So we see that culpable homicide and murder has a relationship, like culpable homicide is the genus and murder is the species. If an act fulfills the conditions of section 300, it qualifies as murder as per IPC, and if it does not fulfill the criteria of section 300, it is culpable homicide not amounting to murder. Now we will be reading these sections in light of the BNS, okay, this section 101 and its exceptions, and also 100, that is culpable homicide. And the second point is that under the legal principles that is established is that the evaluation of facts. The facts of each case must be examined carefully to determine whether the act was done with the intention or knowledge as defined under 299 and 300. So now we will be discussing another case law, that is Narasingh Chalan versus State of Odisha. So this case highlights the judicial approach to differentiate between murder and culpable homicide not amounting to murder. So in this case, the accused was engaged in a sudden fight with the deceased. The accused had hit the deceased with a blunt weapon. The latter died as a consequence of that injury. Now the prosecution contended that the act of the accused amounted to murder under section 302 of the IPC, now BNS section 101, and the accused sought defense under the fact that the incident occurred in the heat of the moment and there was no intention to kill. Thus, the case should fall under culpable homicide, not amounting to murder. Now, we will talk about Kali Prasad Mishra and another versus State of Uttar Pradesh. The case was adjudicated by the Allahabad High Court on October 13, 2023. In this case, the accused was convicted under Section 302 of the Indian Penal Code, that is murder. But later, after an appeal, the court re-evaluated the matter and converted the conviction to Section 304 of the Indian Penal Code, and the appellants were sentenced to 10 years of rigorous imprisonment. The court concluded that the case fell under Exception 4 to Section 300 of the Indian Penal Code, which pertains to culpable homicide not amounting to murder when the act is committed without premeditation in a sudden fight or heat of passion. The murder conviction was converted to culpable homicide not amounting to murder. So I hope that I was able to show some light on the topic of murder and also culpable homicide not amounting to murder. So see you all in the next episode. Until then, bye bye.